Great. Good afternoon and welcome everybody to the first part of our lunch lecture series on anticipating climate change and disaster displacement. My name is Jan-Philipp Graf, and alongside my colleague Sissi Kazzoni, I will be moderating today's webinar on behalf of Ruhr University's Institute for International Law of Peace and Armed Conflict, IFHV, and our research cluster on violent disruptions and forced migration. It will be our pleasure to take you through a discussion on the role of international law in the anticipation of climate-induced displacement.
Good afternoon from me as well. It surely is a great pleasure to welcome both our distinguished speakers and our digital audience for this webinar. It was to our very pleasant surprise that we received a very high number of registrations for this event, because this surely shows that several fellow researchers and practitioners share the same concerns as we do with regard to the response of international law to climate-induced migration. It seems that as the numbers, at least the estimated numbers of climate-induced migrants rise, our expectations of international law rise accordingly. Please feel free to submit any questions you may have at any time in the Q&A section at the bottom of your screen. But before that, we would like to introduce properly our speakers and to hear their responses to some of our questions first.
Climate displacement in international law, it is very hard to miss the expertise of our very first panelist, Professor Jane McAdam. Professor McAdam is the Scientia Professor of Law and Director of the Andrew and Renata Kaldor Center for International Refugee Law at the University of New South Wales in Australia. She has a doctorate in law from the University of Oxford and degrees in law and history from the University of Sydney. She is a leading expert on the protection of climate-induced migrants under international law and serves on a number of international committees, including the Advisory Committee of the Platform on Disaster Displacement, the Technical Advisory Group for the Pacific Climate Change Migration and Human Security Program, and the Advisory Council of the Institute on Statelessness and Inclusion. Good afternoon, or in your case, good evening, Professor McAdam. It is a pleasure to have you with us today.
Thank you so much for inviting me.
While researching climate-induced migration, one cannot but be inspired by the individual opinion of His Excellency Duncan Mhumuza-Laki in the famous Ethiopia case of the Human Rights Committee. Ambassador Laki is an accomplished jurist with extensive legal experience in the area of human rights. After studying law at the McAdam University, Kampala, the Law Development Center in Kampala, and the Illinois Institute of Technology, he worked as a lawyer in Uganda, representing clients with human rights-related matters both in courts of law and the Uganda Human Rights Commission. In 2005, he became legal advisor to the Permanent Mission of Uganda to the United Nations. During his time at the UN, he has been the leader of Uganda's delegation to several sessions of human rights bodies, the vice chairperson of the Finance Committee of the International Seabed Authority, and the vice president of the International Seabed Authority. Currently, he is a member of the Human Rights Committee, the body of the independent experts that monitors the implementation of the ICCPR. So good afternoon, Your Excellency, and thank you very much for joining us.
As we will learn today, domestic courts and authorities play a crucial role in enforcing and implementing international protection standards for climate migrants. Most importantly, judges all over the world decide whether someone has a valid claim to protection because they were displaced by climate change and related natural disasters. We're happy to have with us today Ms. Camilla Schloss. She is a judge at the Administrative Court of Berlin, where she decides on appeals concerning the protection of refugees and other migrants. She previously worked for the World Bank, where she led analyses on gender and land regulatory reforms. She holds a master's degree in international development from Sciences Po Paris and an LLM from Georgetown University. Her research focus is on the intersection of displacement, disasters, and climate change. Ms. Schloss today is, of course, speaking in her own capacity. So thank you very much for accepting our invitation and for joining us today.
Thank you very much for inviting me.
Great. Now, having briefly introduced our distinguished panelists, I think it's about time we moved on to the substantive part of the webinar. So to this end, I would like to start by addressing a question to you, Professor McAdam. Would you say that international law properly anticipates climate-induced migration movements? And which would you say are the boundaries of international law in this regard?
Thank you very much, Sissy, for that question. And let me reiterate what a pleasure it is to be with you all here today. I can see who some of the people are in the participants list or attendees list, and I know among them are some people who are very well versed in this area. There may well be people though who aren't, and so I feel that I'll try and position my comments assuming that some people won't necessarily have a great deal of background in the area, but forgive me if you're well aware of what I'm about to say. So I guess in terms of the role of international law in protecting people who are forced to move in the context of disasters and climate change, the extent to which we can say there is a decent body of law or not depends in a way on whether you want to see this as a glass half empty or a glass half full. Because on the one hand, it's clear that we don't have any binding international legal treaty that specifically deals with displacement linked to climate change and disasters. Well, that is no universal treaty. We certainly do have regional instruments such as the Kampala Convention, which do mention displacement linked to these issues in the context of internal movement in Africa. But we don't have anything that parallels the Refugee Convention. But there are a few framing points, I suppose, that I'd like to raise when coming to the extent to which international law does or doesn't offer people protection. And the first really is one of where movement's likely to happen. We know that already more people move within their countries as a result of disaster-related displacement than they do from conflict. In fact, it's 75% compared to 25%. And the vast bulk of movement in relation to disasters and climate change is anticipated to be internal. So for that reason, again, the role of international law, just bearing in mind how often it will need to be invoked in a cross-border movement context, it's not really going to address the predominance of cases. That said, of course, international law does have a bearing when it comes to protecting the human rights of people who are displaced internally, and the guiding principles on internal displacement recognise that disasters can be a trigger of internal displacement, and that the set of rights and responsibilities that the guiding principles contain apply to people there. We're also talking about a multi-causal phenomenon. So it doesn't make any sense to say somebody's displaced by climate change. Rather, climate change amplifies existing stressors or existing vulnerabilities that may lead to people needing to move. So in the refugee context, if I can move to that now, while we don't have such a thing as climate refugees, we may well have refugees who are moving because their situation is made worse because of the impacts of climate change. And indeed, that was recognised, it's been written about for some time, but it was recognised explicitly by UNHCR last October when it issued some legal considerations on protection in the context of climate change and disasters. And what UNHCR said there was that that we need to be understanding movement in a broader social and political context. And the way that climate change and disasters can disrupt the functionings of government, it can amplify people's fear of being persecuted and the reasons for persecution. And so we really need to be thinking about the deeply social nature of disasters and climate change, within which patterns of discrimination and marginalisation are exacerbated. And there I'm drawing specifically on the language of scholar Matthew Scott. International law certainly contains human rights protections. And so while not everybody who crosses a border because of the impacts of climate and disasters is necessarily going to be a refugee. And the reason is that a refugee is someone with a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group. So even though disasters and climate change may contribute to that persecution, still not everyone is going to meet those legal thresholds. Human rights law certainly has additional roles to play. And I think, we saw the scope for that, at least in principle, in the Tessiota decision that we'll be hearing more about later. Just briefly, human rights law also contains a principle of non-return, the principle of non-refoulement, when it comes to not sending people back to places where they might face be arbitrarily deprived of their life or subjected to cruel, inhuman, or degrading treatment or punishment. Now, the Tessiota decision concerned the right to life specifically, and I won't speak further about that case now. But what it didn't address as squarely, and it was just because of the way the claim was brought, was whether the cumulative impacts of climate change could themselves constitute inhuman or degrading treatment. And there is some scope, I think, for this to be taken forward as a reason why people need protection. Although what one of the hurdles seems to be is the question of when harm is likely to manifest. And I think actually that's one of the crucial differences between the majority view in the Tessiota case and the dissenting view that we're going to hear the ambassador speak about, which was his view. When it comes to there are also, of course, positive human rights duties that states are required to fulfill, and that includes taking measures to try and prevent displacement in the first place. And we've got some very helpful jurisprudence from the European Court of Human Rights not related to climate change, but related to landslides, where those duties are spelt out very, very clearly. That's why states in some situations will have a duty to evacuate people, in some cases even perhaps a duty to relocate people on a more permanent basis. But planned relocations are typically very fraught, and while some governments such as Vanuatu and Fiji have now developed guidelines concerning planned relocation and internal displacement, I think there is recognition that they have to be extremely carefully thought through with consultation with all involved, both those moving and the communities into which they might be received, because there are long-standing intergenerational consequences that can create problems going forward into the future if those things do not occur. So while refugee law and human rights law are certainly vehicles for normative development here, I think it also depends on the lens you want to apply and the context that you're looking at, because people moving in relation to climate change impacts are not a homogenous group of people. And indeed, in some parts of the world, Latin America is a good example, migration opportunities may already exist that enable people to move because of the anticipated effects of climate change or in the aftermath of a disaster. And I just point you to some of David Cantor's work on that. A recent piece in the Chicago Journal of International Law goes through in great detail as to existing migration laws that have and do assist people in this context. I think it's important here to view migration as a form of adaptation to climate change, rather than something that necessarily means that in situ adaptation has failed. And certainly the idea of migration with dignity was something that the former president of Kiribati advocated very strongly for his people in the Pacific. We also know that in the aftermath of disasters, a lot of states at the national level have protected people on a temporary basis and have provided humanitarian visas or waived ordinary visa requirements, have admitted people or allowed people to stay with a temporary protected kind of status. But again, practice varies significantly from state to state and region to region. Within Africa, free movement agreements can help to facilitate admission and stay in the aftermath of a disaster, and Tamara Wood has done a lot of work on that. I think in all of this, planning is key. Obviously, law can't solve everything. We need to be doing a whole range of things to avert displacement, to avoid protracted displacement, and these include disaster risk reduction measures, climate adaptation measures, and so on. Often quite simple things that can actually have a long-lasting impact. And by simple things, I mean, you know, ensuring there are building codes that are in place and are enforced so that people aren't living in vulnerable areas in the first place. There are now a range of international instruments that do recognise and reflect language on climate change and displacement and mobility, perhaps most notably the Global Compact for Migration. And with that, I'll leave it for the next speaker and further questions to elaborate if that's of interest. Thank you so much.
For your response. Bearing these remarks in mind, I would now suggest we look at how human rights bodies in the UN system have dealt with the boundaries of international law so far, and how they have anticipated climate-induced migrants in practice. Precisely, I would like to bring to your recollection that it was only last year that the landmark decision of the Human Rights Committee in Te Tiota v. New Zealand was published. And you already alluded to this case, Professor McAdam. In this decision, the committee took the view that the removal of Mr. Te Tiota to his home state, Kiribati, did not violate his right to life under the ICCPR, since a series of measures were already taken by the national authorities for the mitigation of adverse effects of climate change. However, the decision opened the door for future climate change-related asylum claims. Your Excellency, Ambassador Laki, in your individual opinion annexed to the decision, you took the view that the threshold required for the claimant to be protected from deportation had been met, and you compared the return of climate migrants to the return of a drowning person back into a sinking vessel. What do you think is the role of the UN human rights treaty bodies in anticipating climate-induced migration? Sorry, Ambassador, you have to unmute.
Oh.
Excellent.
Okay, you know, takes long in getting used to some of these things. Thank you very much, Jan, for inviting me. I'm so glad to be in a group of eminent personalities regarding this area. I'm only an activist. I'm a member of the Human Rights Committee, and as far as my other day job, being ambassador and legal advisor to the Uganda delegation to the United Nations, I'm not representing those. I'm here in my personal capacity, and I come as a person who would benefit if sensitivity and more more sensitivity was put to this area. I should say that when I accepted this invitation, I was in Kampala, Uganda, a more user-friendly time zone. Now I'm holed up in Morganville, New Jersey, and it's a rather ungodly hour because I have to be up at 6 o'clock and all this. So, but I hope that I'll be able to hold my own in this regard. And like I have said, I'm here in my personal capacity. That's a disclaimer that we should give credence to. I'm addressing a rather broad question, the role of United Nations system in anticipating climate refugees, and specifically whether climate migration is already recognized, and I think it is. And I will give some examples. I'd like to start by saying that climate migration has been with us for as long as mankind has inhabited planet Earth. Whether it is in biblical times, as was the case when Mr. Jacob, also known as Israel, had to migrate from his famine-stricken homeland that had resulted from long periods of drought. And you can pick this one up in the book of Genesis, chapter 46 and chapter 47 of the Bible. Or whether it is during contemporary times, as was the case in New Orleans, Louisiana, south of where I stand, during the Hurricane Katrina. And there it was reported, among other things, that poor people, especially without cars or any place else to go, were stuck. Some people tried to walk over the Crescent City Connection Bridge to the nearby suburb of Gretna, but police officers with shotguns forced them to turn back. So this is, as you know, climate-related disasters are what led to Hurricane Katrina, and people were basically dying. And here you have a bunch of people who are trying to go to higher ground, and you have police officers chasing them back. So when I considered the Toyota case, I had this in mind. And how do you just send people back to a disaster just because there are other people in there? So really, it was quite a spectacle. And the activist in me actually led to my future joining the committee on the Human Rights Committee under ICCPR. So they were basically condemned to drowning in the flood waters. Then, of course, we have the more recent one of Mr. Teitiota and his family, who sought to dwell in New Zealand in order to mitigate the undignified and uncertain conditions in his native Kiribati. The Human Rights Committee recognized the effects of climate change and has stated that countries that may not deport individuals to face climate change-induced conditions that violate the right to life. The right to life has itself been given a wide range of interpretation by the committee's general comment number 36. So with the coming into force of general comment 36, I think the parameters have been made broad to encompass all these things. Having said that, it's not to open a Pandora's box, so to speak, because only so many people can be taken at a time and stuff. I remember the case of St. Vincent, some Caribbean island recently, when they had this eruption of a volcano, and there was a huge cruise liner which they sent there to rescue people. And as recent as a couple of weeks ago, people were being told that if you are not vaccinated, you will not be rescued. I thought that that is some kind of spectacle for everybody to think about. So we have these things coming, and your imagination is as good as mine, but I think we are taking strides in this area. I like to mention that in Uganda, which has not been prone to these climate variances of extreme nature, the situation is becoming, is lately catching up with regard to climate justice, if you will. And indeed, on Friday, March the 19th, just a couple weeks ago, if you will, in this year, 2021, the Deputy Chief Justice, while addressing judicial officers, he urged them to exploit all avenues available to widen their knowledge on climate justice, in order to have a broad understanding of the subject when they are adjudicating related matters, and address them with a strong foundation in climate jurisprudence. So each day that passes, we are seeing that things are going for the better. And if the question is asked whether this will be something to gain currency, I would say it is. And small steps by and by, are coming in to reinforce that argument. It is noteworthy that these situations are as valid as there is diversity in the time periods, as well as geographical setting, yet with basically the same aspirations. People want to live and to live in with dignity. And many times, of course, climate-related situations have forced people not to live in dignity and to be at the sufferance of the elements. So hence the need to move from one place to another. You may call them refugees, you may call them migrants, but the bottom line is that people need to be to live in dignity, and I'm glad that I was a part of that of that forum, which has increased the parameters, even though mine was just a dissenting opinion. I thank you.
Thank you very much, Your Excellency, for these remarks. And after these remarks on the wished approach towards the protection of climate-induced migrants, I would encourage us to shift our attention to the protection afforded to those seeking asylum based on climate-related claims by domestic decision makers. To this end, I would like to ask you, Ms. Schloss, what is, from your viewpoint, the role of national laws in anticipating climate-induced migration and such asylum claims?
Thank you very much. As Jan-Philipp Graf mentioned already, I'm talking on my personal capacity and due to my academic interest in the topic and not on behalf of the court. I have been involved in the discourse on climate migration since 2015. When conducting research back then, I read always and gathered myself that persons suffering from national hazards are not granted any protection. Professor McAdam had written already back then about human rights protection in her 2012 book. Back then, I must admit, I never quite could imagine how specific claimable rights could derive from the rather abstract concepts of human rights law. Then I started working as a judge in the administrative court, dealing with cases from Afghanistan. I noticed that several attorneys in the asylum cases pointed out to the severe droughts in 2018. I became curious and underwent a review of case law in the public German legal database. And I noticed that indeed applicants seeking protection had invoked environmental conditions before German courts, often in addition to their persecution stories. For example, a person from Somalia argued in 2019 that humanitarian situation in his home region had dramatically deteriorated due to severe droughts resulting in famine, malnutrition, and increased child mortality. Another example, in a 2018 case, a Pakistani national argued that he had left Pakistan because his family had taken out a high loan for fishing, which they could no longer pay back because of a flood that had destroyed their fish farming and other plots of land. How have courts dealt with these arguments of claimants in asylum cases? What is the legal classification? Let me briefly explain the German asylum system for the underlying arguments. In an ordinary asylum case brought before the administrative court, there are three forms of protection. Refugee status according to the Refugee Convention, which all of you, I'm sure, are aware of. subsidiary protection, which is a protection institute within the European Union based on the European Qualification Directive. And thirdly, a ban on deportation, non-refoulement, based on German immigration law in conjunction with the European Convention on Human Rights. In Germany, as elsewhere, neither refugee nor subsidiary protection is currently granted to persons displaced due to natural disasters, especially with regards to subsidiary protection. That is because the subsidiary protection requires the identification of a human actor responsible for the harm in a targeted manner. This is most of the time not the case of natural disasters. But we do not have this requirement of a human actor responsible for the harm for a ban on deportation. And this is why this becomes interesting for national disasters. Let me briefly explain the concept of a ban in Germany. According to the German Residence Act, a foreigner may not be deported if deportation is inadmissible under the terms of the ECHR. This leads to a ban on deportation when a foreigner is threatened with inhuman or degrading treatment, McAdam had mentioned that already, in her or his country of origin with the meaning of Article 3 ECHR. Unlike for subsidiary protection, this ban based on Article 3 ECHR does not require a specific human actor responsible for the harm, as I mentioned already. Rather, the EU courts and the German courts have stated that humanitarian conditions may result in inhuman or degrading treatment and hence give rise to a breach of Article 3 ECHR. This is where national disasters are taken into account by the courts. In determining a ban on deportation due to the humanitarian situation, the courts analyze the conditions in the country of origin, as well as the applicant's individual situation in the cumulative assessment. Again, the aspect of multicultural, the multicultural aspects of migration, which Professor McAdam already mentioned, become here evident. For example, the Higher Administrative Court of Baden-Württemberg mentioned in its 2020 decision concerning an Afghan national the following relevant factors for determining the humanitarian situation under Article 3 ECHR: the general economic situation, the food, housing and healthcare situation, the volatile security situation, the recent COVID-19 situation, and, this is interesting, the environmental conditions. Hence, when conducting this assessment of the humanitarian situation, a significant number of German decisions have alluded to natural disasters, as my research in the German database has shown. In some cases, regarding Ethiopia, Mali, or Togo, the courts mentioned natural disasters only briefly, concluding that the overall humanitarian situation was clearly not grave enough. In several decisions regarding Afghanistan, Iraq, and Somalia, German courts analyzed the effects of natural disasters in a very detailed manner. Droughts were prevalent in these countries, which led to drastic food and water shortages. However, there are heavy limits to the protection. All the decisions emphasize the restrictive application of Article 3 ECHR when the harm is caused by a humanitarian crisis of an entirely natural origin. Article 3 ECHR is only breached in very exceptional cases where humanitarian grounds against removal are compelling. Therefore, German courts seem to be hesitant to grant blanket protection for all returnees to a country. But there are examples where a ban on deportation was granted on an individual basis. In these countries, in these cases, the individual's vulnerability, such as a poor health condition, was the tipping point. The recent decision by the Higher Administrative Court of Baden-Württemberg goes a step further. The overall assessment of the humanitarian situation led to a non-refoulement obligation even for a healthy male applicant which had no family connections. However, and I must say the tipping point was not the environmental disaster, but the negative economic effects of the COVID-19 pandemic. To conclude, as shown, German courts take the environment into account when examining a ban based on immigration law in conjunction with international human rights law. As for now, however, they take the environment into account not as a determining factor, but as a supporting reason in the overall assessment, taking into account the more multi-causality. This human rights protection in Germany ties in well with other legal developments, such as the development of the UNHCR decision, which Ambassador Laki just mentioned. There's also jurisprudence in France discussing bans due to human rights. These cases are examples of how protection for climate migrants might be granted outside the scope of Refugee Convention based on international human rights non-refoulement.
Excellent. Thank you so much for all your remarks. And I have to inform our participants that you, Camilla, recently published an article on Völkerrechtsblog on exactly that issue. And I can wholeheartedly recommend it to everyone. So at this point, I would like to remind our digital audience to feel free to type any questions into the Q&A section at the bottom of your screen. And I've already seen that a number of questions already popped up. Well, in the meantime, Ms. Schloss, allow me a little follow-up question. After listening to your interesting analysis and having also read most of your articles you have written on that matter, I have noticed that rather frequently national decision makers build on international human rights law and on the jurisprudence of international and regional courts, tribunals, other fora, in order to interpret the prohibition on refoulement more broadly and to effectively protect climate-induced migrants. However, as we noted earlier, international human rights fora still maintain a rather moderate attitude in this regard. From your viewpoint, absent a more optimistic guidance by international human rights fora, have national judges taken the matter into their own hands in order to protect climate-induced migrants more effectively? What would be your take on that?
Well, I would consider that a rather provocative question. Well, that would not quite be my view on the matter. We have international human rights, which needs to be interpreted, and it's usually interpreted by the European courts, and they set up the standards of how the human rights are to be interpreted. For example, the high threshold for Article 3 ECHR, and then it's up to the judges, the national judges, to assess in the specific case of the claimant how the situation is. And I would say, since natural disasters are still a rather new phenomenon within the cases of the court, it's up to the court to have to decide how much, what are the effects of the natural disasters on the humanitarian situation. And what I think is very interesting is that we do look at very many reports by international agencies and NGOs, the German embassy, the Australian agency, migration agency also has reports on the situations in the countries. And then we try to assess when is this tipping point, when arrived or not. Yeah. Okay.
Thank you.
Thank you very much. Now, Your Excellency, I would like to address a follow-up question to you. In your individual opinion, again in the Titiota case, you precisely stressed that the facts before the committee re-emphasized the need to employ a human-sensitive approach to human rights issues. How do you envisage this human-sensitive approach, and do you believe that other regional human rights fora, which at times follow much more traditional interpretative approaches and rather restrictive interpretations, such as the European Court of Human Rights, do you think they will face more difficulty in accommodating the protection of climate-induced migrants?
Thank you very much for that question. I must say that if it wasn't for some other considerations, and I hope I'm not quoted on this, but my sense was that the committee saw what was happening in the Toyota case. They all saw that the elements were there, but so to speak, they thought about not opening a Pandora's box by that, by asserting that indeed there was a violation. But of course, as far as I was concerned, the law must be, justice must be done, whether the heavens fall down, so to speak. I think this was a case that, an assertion that was made by Lord Denning in English common law. It is a very famous quotation. So I thought that president or no president, this is something that should be given credence to, but unfortunately my colleagues did not think that. But by and by, I think we are getting to where we need to be, and we shall get where we need to be. And it is small baby steps that we can take to towards this effort. So I would say that, yeah, indeed, the parameters are there. The need for protection is there. And if we make our decisions on the basis of cases that come before us and not other exigent considerations, I think we shall get where we need to be. And indeed, we see this in the Americas. Their court is a little more liberal than the European setting. And I think Africa is towing along the same route. So by and by, I think we are getting where we need to be. I don't know whether I have done justice to this inquiry, but
you surely have. Mm-hmm. You surely have. Thank you very much for your response.
I think the interesting thing is that all members of this panel have at some point written something on the Toyota case. Ambassador Laki has actually participated in the procedures before the Human Rights Committee, but I've just seen that Professor McAdam has posted her analysis of the Toyota views in the American Journal of International Law. And I think you were more or less on the same page as Ambassador Laki, whom you cite a couple of times in your article. And I would like to ask your take on that case. And in particular, if you believe, had the council brought other claims concerning cruel, inhuman, or degrading treatment, or had the case been brought before the Committee on the Rights of the Child on behalf of Mr. Toyota's 3 young children, whether you would have expected a different outcome, and whether you think the Human Rights Committee did a decent job in deciding this case.
Thanks very much for the question. Look, I mean, I think the more I look at the case, which I suppose we should really call it a case, the view, the more I feel that in many respects, it turns on that question of timing. And Jan-Philipp, we were talking prior to the webinar about another research project I've been involved with for a number of years on imminence, and should imminence factor into decision-making when it comes to refugee cases or human rights bases for non-reform, not sending people back. The short answer is it shouldn't. I mean, imminence is not part of either the test under refugee law, nor is it part of the test under human rights law as to whether somebody has a well-founded fear of persecution or a real chance of experiencing or a risk of serious harm. But as I alluded to in my earlier comments, I think that's actually where the distinction is between the majority view, because, and I recognize the difficulty of putting a time frame on this, but essentially they said if Mr. Tessiota, well, he was actually already back in Kiribati at the time, but the feeling was at this point in time, he is not at risk. Now, maybe 10 years, 15 years, 50 years into the future, that could be different, but there might be scope for mitigating actions by the government of Kiribati or globally with, emissions reducing and so on, such that the risk that we can see on the horizon doesn't actually materialize. And this is something that we've been looking at through this imminence project in refugee cases. And there have been a few cases in Australia, for example, where decision makers have been prepared to look a decade ahead, cases involving children, for example. But the test that is used, the correct test, is one of what's in the reasonably foreseeable future. What's the risk there? And that's exactly what Ambassador Laki says in the opinion. In the reasonably foreseeable future, there is a real risk that Mr. Tessiota's life, his life will be at risk. And there's a question that I noticed in the Q&A about, are there any parallels, or could the precautionary principle in international environmental law do any work here? And I think that's where I've referred to it in the past in saying, well, yeah, I mean, the precautionary principle sort of says you don't just wait and see what happens. You actually, it's a bit like an insurance policy. You suspect something could happen and you do something about it. And I guess that's where here on the one hand, we've got the Intergovernmental Panel on Climate Change saying that it's virtually certain that global mean sea level rise will continue for many centuries beyond 2100, and that it's predicted with, near 100% certainty that particular climate change impacts will be felt. So we've got that on the one hand, and yet on the other hand, in refugee law, we've got a test that says even if the fear of persecution is less than a 10% chance, the fact that it's well-founded, that it's foreseeable, can indeed sustain a protection claim. And so wrestling with these two is very tricky. That said, the science does support the majority of the Human Rights Committee's wait and see approach, because the IPCC, for example, has also said that, and I'm quoting now, innovation and investments in environmentally sound infrastructure and technologies could reduce greenhouse gas emissions and enhance resilience to climate change. And they've also referred to other technologies that could mean things that at the moment look dire could actually become things that could be adapted to. So, it's not an open and shut case. In terms of the question about children, reflecting again on that Australian refugee jurisprudence, it would be interesting to see to what extent a claim brought on the behalf of children, their best interests, how that might be examined. Noting too that, questions of intergenerational equity and the like, the horizon involved where children's lives are concerned does, I think, bring different questions into play.
Well, thank you very much. And since we're still somewhat on the subject of the Tessiota case, I might hand the ball, so to say, to Ms. Schloss, because I know she has also commented on the case. And my question would be, how do you think has this landmark decision by the Human Rights Committee influenced the jurisprudence in Europe, in Germany? Is it something you yourself considered, and do you think, is it in line with what the European Court of Human Rights is saying? what is your take on the decision, on the view?
I would say that until now, the decision has not really found any influence in the German jurisprudence. The right to life is also not a question that is the main focus currently in the asylum cases. It's more the question of Article 3 and inhuman or degrading treatment. However, of course, you can convert the analysis also to the questions on the inhuman and degrading treatment. And of course, also the aspect of imminence, or how far in the future is the threat. And what is also maybe an interesting thing, how long will the threat be? Is a question that jurisprudence in Germany deals with and has to deal with. Let's give an example with Afghanistan and COVID-19. Currently, a ban on deportation is granted often because COVID-19 has influenced the economic situation in Afghanistan so severely. But when will it stop? And how will we evaluate when it stops? And so the assessment is always an assessment of the now, but the question, how long of a time frame do we take into account, is something that is not is still open and has still to be analyzed.
Thank you so much. I already see a number of questions coming in directed at all of you. And I think some of the questions may be boiled down to the following question. What do you, the panelists, think about extending the refugee definition? And I'm speaking precisely about the definition of a refugee mentioned in the 1951 Geneva Convention to include so-called climate refugees, because as we've heard earlier, it would be quite hard to fit what we are labeling climate refugees under this definition because of the element of persecution and so on. And Professor McAdam already talked about how it is usually a multi-causal thing going on there. So would it make sense to extend the refugee definition, to amend it? Or do you rather think it makes sense to work with a non-refoulement under the ICCPR or other human rights law treaties? And I think perhaps you have seen the more specific questions going in that direction in the Q&A section. Anybody who volunteers to answer? Perhaps I just give it to you, Professor McAdam, because you've already addressed that issue a little bit previously.
Thank you very much. Yes, I'm happy to do so. And I've written quite extensively on this before. I think Jan Philip, you've kind of, I guess, hit the nail on the head in terms of the causal question, which is one of the predominant reasons why I think simply adding in, climate change as a ground for persecution is highly problematic, because I think it misfocuses our analysis then on, has this person moved because of the impacts of climate change, which, the scientists will say that's a very strange way of approaching. I mean, climate change is something that amplifies risk. But even if we were to say, well, disasters, let's link it to disasters. It's that broader contextual approach that I think is important. And it can misdirect the focus, as I say, to what's caused the harm rather than what rights are at risk here. Which I suppose is what we see more through the human rights non-refoulement obligation. If you're looking at is the person experiencing, or sorry, does the person face a real risk of inhuman or degrading treatment, and what's constituted, what does that constitute, or what constitutes that rather. So there's that problem. There's also a related question of, well, why add disasters or climate change into the mix and not other sorts of things like extreme poverty? What's privileging climate change here? And that opens up a whole host of questions about what's recognized or not, which again, I think the human rights approach can encapsulate. And I think too, a very pragmatic reason is that there's absolutely no political appetite amongst governments to renegotiate an expanded concept of the refugee, either at this stage by opening up the Refugee Convention. If we did that, we could end up, you open up the whole thing, so you could actually end up with a far less expansive definition than is currently there, and people criticize the definition for already being too narrow. But even if you had a protocol, there's currently not that appetite. And I think we saw that during the drafting of the Global Compact for Safe, Orderly and Regular Migration. The specific language that's in there on climate change was the result of a final late-hour intervention by Pacific Island states really pushing for that language to be there. But that document is not a binding document in terms of, it's not a legally binding document. And we've seen governments being very resistant in recent years to adopt binding language on this sort of stuff. So for that reason, I suppose in one sense, if governments are willing to do it, sure, why not create a new instrument dealing with this, or expand the refugee definition in a whole host of areas. But the reality is that's not going to happen. And that's where I think looking to, if we're talking just about protection from refoulement, if we look to the scope of existing refugee law as well as under human rights law, I still think there is scope there to expand protection opportunities.
Well, thank you very much for this interesting take on the question I have been posing before. And I've seen that the number of questions is steadily increasing. And among them, Lauren Grant asked a question directed at you, Ambassador Laki. I will just read it out. So, Ambassador Laki, can you please explain or speak to the principle of climate justice in the Ugandan context? What protections does the Kampala Convention purport for the many refugees residing in Uganda? What mechanisms does it offer for mitigation and adaptation for those coming to and staying in refugee settlements in Uganda from elsewhere in the East African region?
Thank you very much. I should say that Article 5.4 of the Kampala Convention anticipated the climate refugees and imposes the duty on the states. Uganda has been taking a humanitarian approach to effort, really, and many of the refugees that Uganda hosts actually are not as a result of climate change, but usually it is man-made situations like armed conflicts, which forms the bulk of why people are moving into refugee camps in Uganda. Having come to Uganda, we are obliged to cater for them because, first of all, it is in our own selfish interest to take care of these refugees. First of all, we Ugandans have been refugees themselves, going way back to Idi Amin in the 1970s when we had a terrible dictatorship in Uganda and people had to flee. So the current administration notices that and says a good turn deserves another. So Uganda has been welcoming, so to speak, of the refugees that come, and we are only being humanitarian. And that's the approach that we take in order to take care of them as long as we are hosting them. We are obliged by the international conventions, but also, like I usually like to state, it is a common sense approach, a humanitarian approach. Do unto others as you'd expect them to do to you. We've been there, and this is what informs for the most part. But I need to look up something, and maybe in the course of this, I might be able to expound on it more. Thank you.
Thank you. Please feel free to add up on this throughout the webinar. I would now like to turn to a question which is one of my favorites, and I would like to ask Professor McAdam about it, because and I'm very happy that a colleague of ours, Benedict Bellert, added that in the question section. So he says, thank you to all panelists for a highly interesting discussion so far. I have a question to Professor McAdam. The Teota views have been lauded as a landmark case for the protection of forced migrations, and I think rightfully so. Is this now finally the time to recognize that international human rights law has surpassed the Geneva Refugee Convention? It seems to me that the international community's focus on the Refugee Convention has sometimes done migrants a disservice, as states keep highlighting its limited scope. So perhaps highlighting the guarantees under human rights law would help address the problem more effectively. And this brings to mind Professor Chatai's analysis on the unorthodox, let's say, view of human rights law and refugee law, and where most of the protection comes from. So please, Professor McAdam.
Well, thank you very much for the question. And actually, I was going to mention Professor Chatai's work as well. There's another piece about to come out, and this is now a plug for a book that I've edited with Michelle Foster and Catherine Costello, the Oxford Handbook of International Refugee Law. And he's authored a chapter precisely on that relationship there. So another new piece to look at. Look, I don't think I would say that the time has come, or that I don't know that I'd ever say the time's come for human rights law to surpass refugee law. I think they serve complementary and different purposes at times. I mean, perhaps the biggest distinction is that the Refugee Convention, as its full title states, is a convention about the status of refugees. So it actually sets out the rights and entitlements that refugees are owed, as well as, of course, their obligations. And on the one hand, it's easy to say, oh, well, they exist in human rights law, but in fact, the specificity of the status accorded to refugees under the convention isn't reflected as widely in human rights law. And if you look carefully, it's often socioeconomic rights, actually, that are very well protected in the convention. Now, of course, how well they are realised in practice comes down to whether governments are going to implement them. And this actually ties back to my previous answer about, should the Refugee Convention be expanded? At the moment, it has close to 150 states that have ratified either it and or its protocol, and yet we see that refugees remain unprotected around the world. So even if you've got a wonderful document of rights, it requires goodwill by states to implement their treaty obligations in good faith. But I think that status point is very important, because while I've argued elsewhere that beneficiaries of the principle of non-refoulement under human rights law, so people who benefit from subsidiary protection or complementary protection, ought to be given the same legal status as refugees, and in some jurisdictions they are, there's not a sort of a document that sets that out. You can say everyone enjoys human rights, but again, we know that can become quite a fuzzy concept in reality. I suppose the other thing to recognise is the Refugee Convention has been a very robust and flexible instrument. It's been very dynamic over its 70-year history. And so it does protect groups that the drafters probably never envisaged would be protected, notwithstanding the fact that they said, we hope that this will serve as an example that can be, extended in years to come. But, examples are gender-related claims or LGBTIQ claims. And that's why I think having human rights law is absolutely essential as a complement. There are some cases that will fit within the parameters there that won't satisfy the refugee definition. But I think to say one has surpassed the other is perhaps not the best way of looking at it.
Great. Thank you very much for your response. I would like now to ask a further question which has been typed to the Q&A sections by Laura Blade, and I think I would like to ask this question to Ms. Schloss. A question, she says, on the 2020 Afghan case is if the pandemic is considered a disaster, albeit triggered by a biological hazard as opposed to a weather-related or geophysical hazard. Could this support the idea that a disaster was the tipping point of the decision as opposed to a supporting factor which could potentially be applied in the future cases in a natural disaster context?
Do I understand the question correctly, that COVID-19 is understood as a disaster by itself? Yeah, I guess so. It can be, yes, one could see it like that, and one could also then interpret it as as a tipping point or as an example for a tipping point. The interesting thing is that it's of course a general assessment, and it's not also COVID-19 by itself, it's not the health issue itself that is the tipping point, but the economic consequences of COVID-19 on the population in Afghanistan, which led to severe unemployment that was the tipping point. So, and maybe in the end, it's very hard to say what the tipping point is, but it's more an assessment of all the aspects. But I think it's an interesting argument to also look at COVID-19 as a form of disaster. Yeah.
Well, thank you so much for your answer. And I think it was very straight to the point of this question. I think I would like to direct the next question at you, Ambassador Laki. And it's a rephrasing of the very first question we got asked, because in your dissenting opinion to the view of the Human Rights Committee, you speak a lot about the concept of dignity, and that every human person deserves a life in dignity, which is a term you frequently refer to. So could you expand a little bit on what that concept means, and means particularly in the context of climate migration?
Thanks very much, Jan. The committee has, it's the committee's position that the right to life includes the entitlement of individuals to enjoy a life with dignity, and this is to be found in again reference to general comment number 36. It says that you should be free from acts or omissions that are intended or may be expected to cause unnatural or premature death. It is the committee's position that life should not just be living, but living with dignity. Anything short of that impedes on the right to life, and that's where we come from. When that is the bedrock upon which we stand. At least if, for example, sending back refugees to go back to the elements. It's undignified. It's inhuman, as we just seen in the case of Louisiana, where Hurricane Katrina is busy devastating everybody, and people who are running away to higher ground are being sent back. That is a situation that we can envisage for this. And I'm sure if it had come to the committee, they would have something to say about it. Although, of course, Katrina was an internal kind of situation. If it had been transnational, then these are some of the cases that would be highlighted. Because the general comment is very broad. We considered all kinds of scenarios that might impact a dignified life, and I don't want to be sophisticated about this. It is ordinary life with dignity, and you know, so anything that would cause, say, environmental degradation, climate change, and extreme threats would impact on the ability of people to live in this dignity and in a dignified manner, and it would ultimately impact on the right to life. And Article 6 of the Covenant, and as interpreted by General Comment 36.
Thank you very much, Your Excellency. We have a further question by Petra Sushna. I hope I'm pronouncing names correctly. Please excuse the mispronunciation. Thank you so much, she says, for this insightful panel. And she asks further a question to Ms. Schloss. The German Constitutional Court has just recently ruled that legislators have to take precautionary steps in relation to the Paris Agreement in order to safeguard the future freedom guaranteed by fundamental rights. Could this ruling, or rather this understanding of time, have an impact on jurisprudence in the area of climate migration in Germany or Europe, also with regard to the international precautionary principle?
It's interesting because when we were talking before about eminence, I exactly had the same thought, that how you can transfer it. I would say it's probably difficult to transfer this these ideas, because we here quite have, and we have established within the human rights law and the refugees law that we need a threat currently, and it's, I would say it's contradicting to the humanitarian law and refugee law to look at a threat or harm that is caused within 10 years. Because it also goes against what actually the court does with, it always has to look at the situation which is there at the time of the decision that you have there. And another aspect is also, we're looking at, it's always about people that are here, and we are looking at a situation that is in another country. So the question is, can we return a person now to a country? And I would say it's a contradicting to then think of what will happen to the person in 10 years. It's more about what will happen to the person at the time now when he or she returns. Yeah. Okay.
Well, thanks a lot. It certainly seems like this question of the appropriate time frame is very important, and that's why it's probably a very good idea that Professor McAdam is currently working in this project on imminence, to think about this, temporal dimension of law. And I remember an article I read, I think on my first day of law school, in which one eminent old international lawyer said that the problem is that international lawyers don't normally gaze into a crystal ball and can know what is going to happen in the future. But that would certainly be a very helpful device to have. In any case, it has so far been a great pleasure discussing with you and posing different questions to you, but I already see that we're nearing the 90 minutes mark. And so I would like to wrap up the panel discussion with a final round of a more general question, which I would pose to the whole panel, to all three of you. And it's a thought which came to my mind when I was preparing for this discussion yesterday evening, and I was reading some articles in which the authors reflected on the framing of the issue as climate refugees, and that on the one hand, there is progressive jurisprudence coming out of the United Nations system. There is progressive scholarship, which all of you are producing. But on the other hand, there is public opinion. And all around the world, we see an anti-migration kind of populism developing and spreading. So my question to all of you would be, how should we as international lawyers, as humanitarian practitioners, on the one hand, frame the issue and deal with a backdrop against global migration, a problem which certainly will increase within the next years, within the very near future? And perhaps you would like to start, Professor McAdam.
Thanks for the question. And, you know, it's a really challenging one, I think, because also with COVID, we're seeing great changes and disruptions to mobility where people are actually becoming increasingly trapped as well. I suppose, though, in terms of framing, and this is the way that certainly within Australia and what Australia's response might be to people at risk in the Pacific, the way that I put it is this is something that can be addressed very easily. I don't mean climate change, but in terms of some of the risks that are facing people. If I hark back to the notion I mentioned before of migration with dignity, something that Pacific Islanders have been doing forever is moving. And in fact, many have moved and still do to Australia. They're an absolutely essential part of our workforce. And with the pandemic, we've seen that we just don't have people within the country who are willing to take on often some of the jobs that Pacific Islanders have traditionally done. And so those calls for migration from the Pacific can be matched with Australia's own economic interests if we have to be that self-centered, such that it's a win-win for both communities, obviously ensuring that people's rights are safeguarded, that they can move with dignity and with choices. But economically, it's an absolute no-brainer that kind of movement is needed. And at the same time, of course, that I'm not suggesting that that's going to solve and address the entire issue of climate change impacts on the Pacific, but it certainly goes a long way to addressing some of the concerns about whether or not people will have places to move to. And the other aspect of it, I think, is, if I think back to the protection agenda that the Nansen Initiative produced, it's the toolkit approach. It's not it's not we need this huge new international treaty. It can be those simple steps of ensuring disaster risk reduction measures are there, that they're funded, that the technical expertise is provided, climate change adaptation, and so on. And I guess too that if the pandemic has shown us anything, it should be that we're in this together, and that the actions that one country takes or doesn't take are necessarily going to affect others. And in one sense, the crisis that we faced is just a taste of what we will see if governments don't actually up the ante and address these issues now.
Thank you so much. Would you like to go next, Ms. Schloss?
Thank you. Yes, I would well, we have to take into account that refugee protection and human rights protection is basically the last resort that we have, because by then persons are already in another country seeking protection, haven't gone through most of the time an illegal route to get. They have faced lots of problems on the way there. And I also agree that that's why it's also of a very big importance to look at the disaster risk reduction facilities and plan migration to decrease the harm that is caused to people having to move.
Thanks. And would you, Ambassador Laki, do us the honor to have the last statement?
Well, thank you very much. And, you know, as I conclude, it was, I think I saw something about what to do with people who have been displaced by landslides and stuff like that in a poor country. But I would like to say that these countries are not necessarily poor. If you allow the displaced persons to fend for themselves in the local circumstances where they are found. If poverty is going to be measured according to how much resources in terms of money and finances, that's a different matter. But I think it behooves a recipient community, a recipient state, to allow people to fend for themselves, to be facilitated to work in the situation, the circumstances where they find themselves, to have an alternative livelihood free from disaster. But of course, at the beginning, people need to be, refugees need to be assisted to, so to speak, stand on their own. And as long as that is ensured at the beginning, then it would be all right to, I think a state party would be discharging its obligation if they let or went further to facilitate these so affected people to fend for themselves in the context of how the others are fending for themselves. And that's a dignified life. That's not too much to ask, and it would not deplete on the resources that are few. So I believe that if there is not a whole lot of monetary value you can put on helping somebody in a situation of that nature, but some people don't live in the dollar economy, as it were. So allowing them to work with themselves by themselves in the, just like the local population in the areas where they will be put, I think it is dignified, and it would be a welcome gesture, and not just a gesture, really, if it helps to preserve lives. I thank you.
Thank you very much. Thank you very much for your comments and for all these questions that we have gathered in the Q&A section. But sadly, as we have reached our time limit for today's webinar, I would like to once again thank our panelists for having taken some time to join us today and to answer so many questions. I would also like to thank our intern, Paul Stevens, who is inaudible and invisible to the audience right now, but who has helped a lot throughout this webinar with all the technical aspects. And we would also like to thank our two interns, Amelie Freund and Mira Boos, who have also helped us organizing this webinar. Last but not least, I would like to thank you, every single member of this digital audience for today, for having joined us, and we surely hope that you have taken something out of this webinar and that you will feel more comfortable anticipating climate migration, either as advocates standing by climate migrant sides or as national or international decision makers.
Well, also, thank you so much from my side for joining us today. It has been a great pleasure moderating this panel, and to all the panelists, you made it very easy to moderate this panel with your great answers. Before I adjourn this session, I would kindly like to remind you to join the second and third webinars of this lunch lecture series on the anticipation of climate migration. Apart from that, thanks again, and have a nice afternoon, evening, or morning.
Morning.
Thank you so much.
Thank you.
Thank you.
Thank you.
I will now end the webinar, so everyone will be kicked out. Well, best wishes to everyone. Goodbye and thank you.